Hello, everyone, and thank you for joining us today. This is the second talk of our BPJ series that we often host for junior members. And today, Angus and I will be focusing on relief from sanctions applications. I'm told the next seminar will be hosted by Charles Towell and Alex Bradford, so please do stay tuned for that one. I think we should start off by apologising to everyone for taking you away from enjoying the sunshine, which we rarely get. And I have a feeling it wasn't the easiest decision to join the Teams meeting at 5 p.m. today, to have to listen to Angus and I for an hour. But we do hope that you can take away some tips and tricks when faced with a relief from sanctions application. So if you are in the garden with your camera switched off, there is seriously no judgment. Please enjoy the talk. And finally, if you do have any questions, then we will be handling them at the end. So feel free to just use the chat function and we will be able to view them at the end. So let's have a look at the agenda for sort of the next hour. Angus is going to kick things off with sort of background to the legal framework to bear in mind when making a relief from sanctions application. So this will include the relevant CPR provisions and the well-known test in Denton versus TH White. He will then tie that in with when a relief from sanctions application is triggered and talk you through the relevant CPR provisions which may have been breached. I will then jump in and use a case study to demonstrate how the legal framework comes into play when preparing the application notice and the witness statement in support. We will then discuss how to respond to an application for relief from sanctions, or whether in fact it should even be responded to, and we'll also touch on applications made by litigants in person. We'll both then finish with a list of key takeaways to have in mind when dealing with relief applications. So I'm now going to pass over to Angus, who will begin with laying down the foundations.
Thank you very much, Aman. And yes, thanks everyone for joining us on what is a really especially pleasant and sunny afternoon. Sorry to take you away from things you no doubt would rather be doing. And to be honest, we'd rather be doing those things too, but there we are. I'm going to set out the legal framework, which most of you will be entirely familiar with anyway, but I'm going to draw on two recent cases that expand on relief from sanctions applications and might be kind of useful. You should all be familiar with Civil Procedure Rule 3.9. This sets out the circumstances in which the court can grant relief from sanctions. And as I say, it'll be familiar to you. But the court can grant relief from sanctions where there's been a fail to comply with a rule, practice, direction, or court order. What is the court going to take into account? All the circumstances of the case so as to enable it to deal with the application justly. Part of this assessment will include consideration of the need for litigation to be conducted efficiently and at proportionate cost, and also to consider the need to enforce compliance with rules, practice, directions and orders. So A and B there derive from part one of the civil procedure rules and very much in line with the sort of post-Jackson reforms. A point here is subsection 2, something that we'll come on to in due course, but an application for relief is supposed to be supported by evidence. I'm sure Aman has seen it in practice, but I have too. Quite often you do see applications for relief and sanctions without evidence, but we'll come on to that shortly. Again, you all know this, the tests, Denton and TH White. There's three limbs to it: the serious and significance of the breach, why the default occurred, and all the circumstances of the case. As I say, it derives from the Court of Appeal case, Denton and White, which was post the Jackson reforms. and it swept away the old newspaper group test that used to apply. But the focus now, and has been for the last 10 or so years, it is on these three limbs. I'm sure you've all been taught this before at law school, so there's no real need for me to go into what this all means. But in short, serious and significance of the breach, that consideration relates to the materiality or impact of the breach. How does it affect the course of the proceedings? And at this stage, the court will also consider the rationale behind a certain procedural rule or a court order. Why did the court put that order in place? Is the breach of it a significant one within the context of the proceedings? If you fail on that one, you're moving on to why the default occurred. If you fail on that, you're moving on to all the circumstances of the case. So in short, in order to get relief, you need to satisfy each of these. Why the default occurred, again, similarly to seriousness and significance of the breach, it's not as if the courts have defined in full what a good reason is and what a bad reason is. There's no definitive list of the types of breaches that are serious or significant, and there's no definitive list of what's a good breach, what's a good reason for breaching an order, and what's a bad reason. It's all very fact dependent. But generally, a good reason for the breach will be something that's outside of the control of the parties. It might be that there was a sudden illness or an accident, which meant that the lay client or the solicitor couldn't file that witness statement in time, but simply overlooking a date, not remembering that you had to do something by a certain time. Generally, that's not going to be a good reason. There's no hard and fast rule on this, but I think it's important to be aware of those kind of parameters. And last of all, the circumstances of the case. And since Denton, and in fact before, there has been some authority on what is all the circumstances that the court will take into account. Some of that includes the past conduct of the party in default. Are you regularly somebody who's breaching court orders, or is this your first offence? What is the prejudice to the other party? Are we at a stage of proceedings where the trial is looming, it's coming up in a few weeks' time, and your failure to pay the court fee means that that trial needs to be vacated? What is the impact on case management? Are we at a stage where various directions have been set, and your failure to comply with one of them means that everything now needs to be pushed back? And lastly, there'll be consideration of the interests of justice, which comes into pretty much any procedural application under the CPR. But again, the focus on the need for efficient and proportionate litigation, the need to enforce compliance. Tied up in that as well, I'd say, is the need to make an application promptly. Have you sat on this default for some period of time and not done anything about it, or have you taken active steps to undo your mistake? These are all the kind of considerations, and we'll touch upon some of them in due course. I think Aman would agree that more often than not, we see in practice cases that I wanted to highlight to you, and perhaps do nothing more. But the first is F, X, and F, and English Karate Federation, a Court of Appeal case from 2023, a couple of years ago. What this case helpfully set out was the nature of relief from sanctions applications and pose the question, when is it actually required? So now, having set out what a relief from sanctions application is all about, it's important to think about, do I need one in the first place? And that case set out three scenarios where a relief from sanctions application might be required, by framing it in terms of the sanction to be applied. So the first there is an express sanction. These are the ones that you'll be most familiar with. They're cases where there's been whether there is a procedural rule or a court order which expressly sets out what the sanction is for failing to comply. So a failure to file a witness statement on time, that has a particular sanction, whereas some others don't. And this is where you're looking at implied sanctions, the second limb. So cases where you have a court order which says you must file an expert report by a certain date, and if not, permission is required. So there's no express sanction for failing to do this within a particular time, but you'll be looking for not relief from the court, but permission, and there's a particular power for the court to do that under CPR Part 3, but that is distinct from CPR 3.9, relief from sanctions. And there's also the scenario which many of you will be familiar with, where a further step is needed as a result of the non-compliance. So if you fail to file your defence in time, the sanction that takes effect is the ability for the claimant to apply for default judgment. And similarly, if you don't attend trial, often the consequence is the striking out of the claim. In that scenario, the test mirrors that of relief from sanctions, although a distinct application will have to be made, describing itself as an application to set aside default judgment. Part of the test is Denton and White. But remaining on this theme of relief from sanctions and when is it actually required, another helpful authority that judgment was given in last year is the case of Yes Electrical Limited and Warren. Here the court provided useful guidance again about the steps a party should take where there's been some kind of breach. So firstly, what you want to do is identify if whether a rule or practice direction or court order has been breached. If there's no breach, then there's no need for relief. If there has been a breach, you move on to part 2. You want to identify any sanction for that breach, that being a express sanction within the rules or a court order. When I say a court order, it could be something like an unless order. Unless you comply with this direction by a certain date, the claim is struck out, for example. And if there's no express sanction, again, we're looking at the scenario of implied sanctions. So in this case, it relates to the F, X and F case I just mentioned. And there's some authority from Sayers and the case of Altomart related to appeals. But if your case doesn't fall into any of those categories identified by the case law, there's no need to actually make a relief from sanctions application. So an example of this would be a witness statement. You're told by the court that you need to get in a witness statement by a certain date. If you're unable to comply with that date and you know it in advance, you're not in breach. You haven't failed to file a witness statement in time, but you anticipate that you will be unable to. There's no breach. You're not looking for relief. You're simply asking for an extension of time, which again is an application that falls underneath a different part of the CPR. So to label your application as a relief from sanctions application wouldn't be quite right in that scenario. But what the case of Yes does tell us, and it's supported by other bodies of case law as well, is that even though you're not applying strictly for relief, in essence, the ethos of a relief from sanctions application, the ethos of Denton, should still be borne in mind. So when applying for an extension of time, it's not simply good enough to say, look, Judge, I can't comply with that, I need a bit more time. You want to be thinking about why is it you can't comply? What are your good reasons for not being able to stick to the original deadline? You want to be thinking about the effect of not being able to comply on the progress of the case and other directions. So these are considerations that you'll want to be putting into an application that very much mirror relief from sanctions. But it's not right to say that it's strictly a relief from sanctions application, and you shouldn't dogmatically follow the test. So moving on, the next part of the talk that we thought might be helpful is simply to identify some of the common types of defaults that occur, some of the ones that we've seen in practice. So where is it? So scenarios where a party's got it wrong and will need relief. Perhaps one of the most serious breaches that you can, or consequential breaches that can happen, is the failure to pay a court fee. I in fact had this only the other week, and there is an express sanction for this. So it's the first limb of the FXF case that applies. Automatic strikeout of the claim or counterclaim, a really serious consequence or sanction. Your application there would be a relief from sanctions application. What you're asking for is a reinstatement of the entire proceedings. The failure to comply with an unless order. Again, this is an express sanction that's set out in this case by the court. An unless order says, unless you comply with this by a certain time, often you're going to be struck out or you're debarred from relying on the evidence that you otherwise would have had. Clearly, a serious matter in most cases, in that it derives from a judge, but not always considered serious and significant in the context of a relief from sanctions application. I have my own thoughts about that, and I think often if you're going back to the same judge who made the order and you're saying it's not a serious or significant breach despite you, judge, having made the order, sometimes that won't go down too well. So there are tactical considerations to think about when arguing for or against there being a serious or significant breach. But the authority is there. Generally, it's going to be serious or significant, but not in all circumstances. Another express sanction, which in my view is again pretty unforgiving, is the failure to file a cost budget on time. This will be in advance of a CCMC. I think that the deadline is around about 21 days prior to the CCMC. The parties must file and exchange their cost budgets. If you fail to do that on time, even by 1 day, your client's costs will be restricted to the court fee alone, which could be a number of £100 as opposed to the £50,000 that they might otherwise have sorted by way of cost budgeting at the hearing. Again, a relief from sanctions application would be required. Missing deadlines in general, and I suppose this is the most common one that will occur and the most common one that Aman and I regularly see. As mentioned before, if your application is prospective, you're suspecting that you're not going to be able to, or you know that you're not going to be able to comply with a court deadline by a particular time, you don't need a relief from sanctions application. If, however, it's retroactive and you're looking back and you're saying, well, we were ordered to file the witness statement last week and we didn't, sorry for that. That is an out of time application where you're seeking retrospective extension of time. And that in that scenario, when the deadline's gone, you've missed it, you are seeking relief from the court. On witness statements more generally, or in particular, the rule is set out there in Part 32. If you fail to file a witness summary or witness statement in time, one that's intended to be used at trial, the express sanction there is that your witness can't be called to give oral evidence unless the court gives permission. So here, a clear example of an express sanction, one that you require relief for. And then looking on to the third limb in F and X, this is where this comes in relation to a defence. So if you fail to file and serve your defence in time, the claimant may obtain default judgment, or otherwise the claim is stayed for a period of time. So another example of there being a sanction in place, but this time contingent on some action being taken. In both situations, you'll require relief from sanctions. One way you won't often require relief from sanctions, but is worth mentioning, is the failure to file a bundle. I mention this only because there's a particular rule in relation to appeals that if you don't file your appeal bundle in time, which is usually a period of time after you filed your appeal notice, that can cause the entire dismissal of the appeal. And in that circumstance, you will need the court's relief. More generally, if your hearing's next week and you're ordered to file and serve your bundle 7 days in advance, there's always going to be a risk that the court hasn't received your bundle, even if you file it a few days late. That, of course, the real effect is that you're probably going to have the hearing adjourned off. You're going to have wasted costs made against your clients, and in some circumstances, you might be barred from relying on documents that you don't have permission to rely on, but simply something to be aware of. So that's my summary of the legal framework and some of the common scenarios that we see in practice. But the real meat of this talk is a case study. So I'll hand over to Aman, who'll talk to you about that now.
Thank you, Angus. That was really helpful. And what we're now going to do is utilise those points that Angus has touched upon to analyse a case study to help us understand how that framework actually works in practice, and how we can use that to prepare a model application notice and a witness statement in support of an application for relief. I'm going to apologise in advance for the lack of any imagination in this set of facts, but I thought, given the circumstances of relief from sanctions application, it would be best to have something quite relatively straightforward with not many too confusing deadlines, and hopefully we can apply the Denton test and see how a witness statement and application notice can most effectively put those points across to a judge. So in this case of Smith versus Greenway Construction Limited, the claimant, Mr. Smith, sues Greenway Construction Limited for breach of contract related to faulty building work. The witness statements in this case were due on the 1st of March 2024 by a court order. The claimant's solicitor mistakenly believed the deadline was 15th of March 2024 due to an internal diarising error. The claimant filed his witness evidence 13 days late on the 14th of March 2024. The defendant applied to strike out the witness evidence and opposed the relief from sanctions. So already here we can see that there has been a breach of a court order, which would be considered as a serious and significant breach. The sanction is not apparent on the face of the fact, and we don't know what the court order actually said. However, there is an express sanction, as Angus touched upon, in CPR 32.10, which says that the failure to file a witness statement would ordinarily mean that the witness statement cannot be called to give evidence, unless, of course, the court gives permission. So now we've identified the breach and the sanction. This is a case which squarely fits within the brackets of a CPR 3.9 application. We know the default occurred due to an internal diarising error, and we know the claimant filed the witness statement 14 days late. So these 2 points will come into play when considering the final limb of the Denton test, which is in all the circumstances of the case. And what we would expect to see in the witness statement in support are the reasons why there was an internal diarising error, how that error occurred, whether the defaulting party has defaulted before, what is the prejudice to the responding party, if any, where are we in relation to the trial timetable, is the fact that the witness statement that was served 14 days late really prejudicial to the court timetable or the respondent? Have the parties been in any communication about the late filing of the witness statement, and was this application anticipated? So with those key thoughts in mind, let's consider how to approach the application itself. So on the screen, you can see that there is an N244 application notice. So you obviously want to first make sure that you've got the correct application notice. And after you've completed box 1 and 2, it's usually in box 3 where things can often start going wrong. And box 3 is small for a reason. And what you want to do here is clearly state, firstly, that you are applying for a relief from sanctions application under CPR 3.9. Had a case recently where there were 2 breaches, or one anticipated breach, should I say, and one breach, and it was for the failure to file witness statements in time. One part of the application was dealing with a retrospective application for relief from sanctions, and the second part of the application was dealing with seeking permission from the court, essentially, for prospective relief. And the application in and of itself hadn't actually stated that it was applying for relief from sanctions. And so procedurally, that was a deficiency which the responding party had picked up and stated that on the face of it, it wasn't actually apparent that there was in fact a relief being sought in respect of the retrospective part of the application, because as Angus distinguished, prospective permission is not an application for relief from sanction. However, in that case, all was remedied because the witness statement in support had in fact touched upon the Denton test and touched upon the circumstances relating to those 3 parts of the test. So when you've identified that you're applying for relief from sanctions under CPR 3.9, very briefly, you should also include the breach itself. So identify the breach and identify what the sanction is. Briefly explain why that breach occurred and why relief should be granted. And this sort of just gives a taste to when the judge picks up this application, either in box work or just before the hearing, because these sorts of hearings are usually listed for a very small amount of time. And it really does assist the judge with just getting over the initial hurdles of why the parties are actually making this application, or why in fact it's being, or whether it should be in fact opposed. Then the next box asks if a draft order will be filed to assist the judge. And I would always recommend that filing a draft order to assist the judge with the directions that are being sought is always beneficial, especially where a relief application is covering numerous breaches and there are numerous different sanctions. But also often relief from sanctions applications almost bolted on to other hearings. So whether that's, for example, a trial hearing, or whether, for example, that's a CCMC or other case management hearing, it's really good for the judge to sort of know what direction the application is heading. And that feeds into the next box, really. So more likely than not, a hearing will likely to be required, especially obviously when an application is opposed. And the thought here really should be given to the complexity of the facts, the reasons for the application, and whether it is going to be opposed or not. And that will be the key factors in determining how long the hearing will take, which is why we said earlier that some thought really should be given to whether or not there has been correspondence between yourself and the opposing party, so that you have an indication as to whether or not the responding party is staying neutral, for example, and then encouragement can then be given at this stage to perhaps deal with the matter on the papers, or whether in fact, for example, a litigant in person has perhaps made this application and a hearing ought to be listed. The next part is the level of judge that is required, and more times than not, the level of judge will likely depend on the track of the matter that it's allocated to, and which court the matter sits in. But more often than not, it's safe to say that it would usually be dealt with by a district judge or a deputy district judge. In terms of service, ideally the opponent should be served with the application at least 3 clear days before the hearing. Again, I know sometimes this can be quite difficult, especially where the scheduling or the timetabling is quite tight, but ideally you do want to give 3 clear days before the hearing, and indeed that's what the practice direction states. And finally, box 10, which isn't on the screen, but as I'm sure you're all aware, it follows on and it asks you what evidence you are relying upon. And I would always recommend that you attach a separate witness statement with exhibits. Witness statements are absolutely crucial because not only are they required under CPR Rule 3.9 subsection 2, but they also, if done right, can be very helpful in describing the factual circumstances of the breach and how it might have been mitigated when persuading the judge why relief should be granted. So on that note, let's have a look at what you should avoid doing when preparing a witness statement. So on the screen here is an example of quite a poor witness statement. And in red highlight are those statements which I'm going to go on and critique. But unfortunately, we often see when we are instructed on relief from sanctions applications. So if you want to have a few seconds to sort of have a quick, brief read through while I'm nattering on, there is quite a lot of red line there, and quite justly so. And first, what I would start with is a witness statement is there to state facts. And this particular witness statement has way too much legal argument. The solicitor or in fact the lay client who it's being drafted on behalf of should really only state the facts which the witness personally knows, not legal opinions or advocacy points. So for example, in this particular witness statement, there's a sentence which says, "In my professional opinion, this delay wasn't serious and the application should succeed. The claimant has a good case and it would be unjust to prevent him from relying on his evidence just because of a simple mistake." I think Angus will agree here, and perhaps might even expand on this particular topic. But often we do see witness statements which attempt to almost mimic a skeleton argument, and they go on to make persuasive sort of points of really that should be left to the advocate, or touch upon the Denton test in quite too much detail. And it really detracts it from the circumstances which have brought this particular application. I think, Angus, did you want to sort of, I think you had something recently, didn't you, where we were talking about this?
Yeah, Alan and I were talking about this today and the sort of statements that we've seen in the past, but it's a bugbear of mine, and I'm sure other people as well, but you'll often see in witness statements for relief from sanctions applications in particular, headings of why serious and significant and why the default occurred, and properly labelling it out as if it were a skeleton argument or submissions. And that's wrong because the civil procedure rules are clear about the content of witness statements and what their purpose is, which is truly to give that individual's recollection of what happened. And I think to stray into legal argument in a witness statement in circumstances where you're asking the court for its indulgence to grant relief, I think is actually quite dangerous more than anything. These applications are important, and it's why we're doing a whole talk on it today. And it's important to get it right. So in as much as you can reduce the things you're doing that might frustrate a judge, you should. And part of that, I think, is avoiding giving too much opinion evidence, giving too much legal submissions. I think in many respects, this witness statement isn't so bad, and I've seen worse than this, but it's certainly an important thing to think about.
Yeah, and on that same sort of line of topic, where a witness statement is quite unprofessional in its tone, and it introduces irrelevant material that can also put off a judge. So, for example, complaining about the previous judge's decisions about timetabling, talking about other cases, or even blaming the colleague who perhaps might have ought to be responsible for the breach in and of itself, is inappropriate. So, for example, in this witness statement, there's reference made to the assistant is relatively new and still learning the ropes. We'll see on the next slide shortly where the same set of facts can be interpreted and explained in a better way, even when you are sort of trying to tiptoe around why the breach occurred, especially when there isn't really a good reason for that. And we are all human, and errors do happen, and the court can be understanding of them if it's communicated properly and explained with evidence. In this case, in this particular witness statement as well, there's a mixture of facts and opinion where she goes on to say, in my opinion, the judge didn't give us much time. Again, that's very unnecessary and potentially harmful, especially if you're, before the same judge again. I would definitely not recommend that. And of course, you never know what judge you're going to get, if it's going to be the same one or not. Over explaining things, so particularly when explaining the breach that occurred. In this case, in this particular witness statement, and this discussion of another unrelated case, where she said, I wasn't aware of the diarising error because I was very busy with another big case that was going to trial at the same time. It was a commercial dispute worth over £5 million, which took up most of my time and attention. Again, that's not going to come across very great. It actually adds clutter and it sets quite an unprofessional tone. There's also a lot of finger pointing in this witness statement. So I would say don't find comfort about your own client's breach by finding faults in the other side's conduct, because at the end of the day, this is your application. To some extent, although the judge will look at the wider circumstances, it's not going to be helped by solely looking at the respondent's conduct. It really is focused on the person, on the party that's making the application. Some formatting errors here as well. There's a lack of paragraph numbering, which I anticipate none of those joining us today would even dream of doing. But obviously, paragraph numbering is mandatory under Practice Direction 32.7.4. And paragraphs should be numbered for easy reference. And also there is an incorrect statement of truth. Again, sometimes these sorts of witness statements are made quite quickly and in haste, but I would emphasize the importance of making sure the formatting of these witness statements are accurate and ensuring that the practice directions are followed in relation to witness statements. It's just quite ironic sometimes. It's usually the failure of following the practice direction of witness statements. Often you find yourself in these situations. So now you're aware of what not to do. I think what might be better is if we look at the better way of communicating the same facts, but in a more efficient and cogent manner, which makes the application look a lot better and more persuasive. So on the screen here, you can see lots of green, which indicates very good. And this statement is good because it only focuses on the fact. So again, if you want to take a few minutes, just sort of get yourself familiar with sort of the green parts of this witness statement, which will automatically jump out at you. You can tell here that the statement really does only focus on the facts. There is no argument like there was in the previous witness statement. The breach is clearly stated. So she says, unfortunately, due to an administrative error, the witness statement deadline was incorrectly recorded in our internal case management system as 15th of March 2024. It's factual, it's punctual, it's to the point. It picks up that it's an administrative error. It picks up that it was, on a case management system. Often these things, different firms work differently, and sometimes some detail where it's actually required can often be quite helpful to a judge, when a judge can understand, okay, so clearly they have a system in place where cases are managed in a certain way, and if your fingers rolls over to the next keypad, then obviously it's going to insert an incorrect date, and that happens. It's human error. although that might not be a good explanation as to why, but I think it really does help in allowing the judge to understand how the breach occurred. It's clearly explained how, for example, the miscommunication between herself and the junior member of her team occurred. So you'll remember in the previous witness statement, there was almost sort of this blaming attitude and finger pointing attitude at the younger member of the team who was new and recent. Quite frankly, the judge isn't so bothered whether someone is new to the team. What they want to know is how that error in fact did occur. And it's explained there was some sort of miscommunication where the junior member of the team had inserted the date incorrectly, which again, it's the same point, but it's put across so much more better in such a way that it has a more professional tone. So this witness statement is also better because it's concise while still elaborating on the Denton test. So I think what can often be confused is although CPR 3.92 says it requires evidence in support of the relief from sanction application, when it comes to the witness statement, it really means evidence in relation to the factual part of the proceedings. So it's not so much that it's not so much that evidence is required in terms of, okay, this is how the Denton test works in relation to this case. It's more so that these are the facts which gives rise to the limbs of the Denton test. So, for example, here, the solicitor here has quite clearly said the delay was not intentional. It was a single isolated administrative mistake. No prior deadlines in this matter have been missed. The delay has not disrupted any scheduled hearings or otherwise impacted the litigation timetable. It goes on to tell you that the trial was listed for July 2024, and to my knowledge, the defendant has not served their witness statement evidence as to the date of this statement. So quite clearly, there's a very different approach to setting out quite clearly the trial timetable and how even though the witness statement is 14 days late, there is still ample time before trial, which isn't till July, some 4 months after. There's ample time to digest the information, and that is a lot more helpful than saying that in all the circumstances of the case, the defendant has acted this way. Sorry, the respondent has acted in this manner and has itself not complied with the rules. Whereas here you're taking a more proactive approach to say, okay, well, this is this was a deadline. We accept it was serious, it's significant. It's made concessions where necessary, but it's also explained the impact of the breach and how it's not prejudicial. The other good thing about this witness statement is that you can see there that there are uses of exhibits. And I would say that this is a really good way to demonstrate to the judge where you can point to correspondence or certificates of service in relation to the responding party, particularly where an application such as this is opposed, because then you can have sort of a track record of, okay, this is what was happening. You can see this quite clearly. We corresponded with the other side on this date. They accepted that we were going to make this application, yet they still opposed it. There is a real gift in making sure those exhibits assist the judge by demonstrating that you've made a very reasonable and fair approach prior to making the application. Again, here, obviously, paragraph numbering throughout, and again, there is a proper statement of truth. I can just see that someone has just put something in the chat function, which I was just going to quickly have a look at. I'm not sure I understand the wording at paragraph 5 of C's application for relief. So paragraph 5 is the failure to breach a court order is serious and significant. However, the delay was not intentional. It was a single isolated administrative mistake. No prior deadlines in this matter have been missed. So I think what's happening there is that the solicitor is basically making making a concession, which again comes across very well. There's an element of remorse there, an understanding of the Denton principles, and also explaining here that there was no intent, there was no delay tactics involved with filing the witness statement late, and that it was a single isolated administrative mistake, again highlighting that this is the first of hopefully no other breaches in all the circumstances of the case. So with that in mind, and knowing how to sort of tackle a witness statement in the best way possible, even where you are the defaulting party, I think Angus is now going to take over and talk about how to respond to such applications.
Yeah, so what do you do? Your opponent in your current case attended this afternoon's seminar and very carefully made notes on Aman's witness statement that she's just highlighted there. So they brought this really good application for relief from sanctions that sets out fairly and squarely what's gone on and why they're entitled to relief. What are you going to do with it? How are you going to best represent your client, and what's the advice? Well, I think a really important consideration whenever responding to a relief from sanctions application is the issue of costs. And often we see in practice that ultimately a large part of the fight is going to be about costs. But in Denton itself, the court's made very clear that they don't like gamemanship. They don't like one party seeking to take an undue advantage of somebody else's mistake. And the real focus is on having proportionate and efficient litigation. So the courts can and they will make adverse cost orders against your client if they unreasonably oppose a relief from sanctions application. That's not always going to be the case, but it comes down to a matter of judgment. And what Aman and I would advise you to do is to look at any draft application that's provided to you from the other side, or any correspondence which indicates that a relief from sanctions application is going to be made, and review it, see what it says. Are they concessionary about some points? Do they accept that what they've done is serious or significant? Do they accept that actually they don't have a good reason? But looking at the case overall, this breach is not going to have serious effects on how the litigation is going to unfold. It's not prejudiced your client in any way, and it is overall on balance appropriate to give relief. I've made this application promptly. I've set out in a witness statement what went wrong, and I've held my hands up to it. That's the kind of application broadly that you'd expect not to be resisted, but rather it's the kind of application that you either remain neutral on or you consent to. And it's due to this risk of having adverse costs orders made against you, and looking at it from the other side, if it is your application for relief and you're confident in your application, one of the first things you should really be doing is setting that out to the other side and seeking their consent. You want to be contacting them saying, we're aware that you know that we're in breach of this court order. We failed to file a witness statement in time, but it's because the witness was in hospital and she was unable, due to an emergency or whatever, and we were unable to take that witness statement from her. Clearly, depending on all the circumstances of the factual background, that feels like the kind of application that would succeed. As the applicant, you want to be reaching out to the other side, explaining that, seeking their consent, but also when doing so, seeking their consent for the reason that if you don't consent to this application, you need to be aware and you need to be advising your client that there's a risk of having costs ordered against you. But in general, provided that you as the respondent haven't taken the opportunity to unduly resist a relief from sanctions application, even if that application is granted, you have an argument that you're entitled to your costs. This is contrary to the usual rules of, relating to the winner receiving their costs from the other side, but it stems from the fact that the applicant will be in default and in breach of some court order. So why should your client have to go to the expense of reasonably resisting or opposing a relief from sanctions application? So just something we wanted to highlight as being really important here. Have they made a half decent application for relief from sanctions? Is it worth really opposing this and perhaps making some pretty weak arguments your end as to why relief shouldn't be granted, in view of the fact that if they're successful, which they may be, your client might have cost orders made against them. But we're quite aware of the realities of what litigation looks like for many junior lawyers, us included. And you're not always presented with these really great applications that you should be consenting to for fear of costs being ordered against your client. More often than not, you might be dealing with unrepresented parties who don't know the ins and outs of the procedural rules that we do. That is what you're more commonly faced with, and so Aman's going to briefly touch on how you might respond to litigants in person when they seek relief from the court.
Yes, thank you, Angus. So more often than not, litigants in person will tend to turn up to a hearing with a whole load of correspondence that you've sent them, and they'll pick holes at what you've sent. They'll make all sorts of accusations about how the solicitor is trying to use the law to their advantage. They know I'm unrepresented. And what you want to do in these sorts of situations is completely contradict that by relying upon the correspondence that you've sent to the litigant in person previously, which is actually fair and accurate. And in the table there, I've sort of set out what tends to often happen on the green side of the column. Yet you're still faced with litigants in person that have often missed the deadlines, that have often sought indulgence from the court on multiple occasions. Yet the party that's being represented is quite often left quite bemused after and quite confused why the court again allowed relief to be granted. And so sort of the tips and tricks really there to hone in on it are that always acknowledge any correspondence received from the litigant in person and maintain that professionalism even when you're provoked. It can be quite useful to sort of point out any failures whilst referring to evidence, and then again offer guidance and not advice where appropriate, and always copy in the litigant in person and explain your next steps when writing to the court. I think it's quite a difficult one to navigate, really, and I think at the junior end in particular, we are often faced with applications from litigants in person who don't really know what they're doing. They don't know what the Denton test is. They don't know what they're trying to satisfy the judge of. But where you have a sort of a chain of correspondence where you've quite clearly said, this is what the court order is, here is our evidence, we expect a response by X date in accordance with the order made, it can be quite useful when turning up to a hearing against litigant in person, and also quite persuasive when you can tell the judge that, well, we did make he or she are aware of the next deadline. We wrote to the person on these occasions. Here are the letters. Here are the emails chasing up a response. but it was, for example, radio silence, which it often can be. And I think really the tactic here is to make sure that you have a chain of constant correspondence, even where any communication from the litigant person is repetitive or it's aggressive, rather than sort of retracting and then coming to the hearing and saying, well, judge, you can see what they've done here. It's completely wrong. Surely you can't grant relief. Whereas the opposite approach usually works best is when you can point to that correspondence that you've sent and highlight the fact that there has been a level of guidance and that there is no real good reason why they couldn't have met a deadline that they were reminded of about 3 or 4 times. I think Angus is going to touch upon that a bit further with some experience that he's recently had.
Well, yeah, it's something that does happen now and again. But I'm also aware that we're coming towards the close of an hour, so I don't want to take up too much time with my war stories. But I think the purpose of this is really to show that you will get applications from litigants in person who don't know what it is they're asking for. They'll make applications without supporting evidence, and it's quite helpful to alert a judge to the pitfalls in their application, setting out what it is that you would do if making the application properly yourself, that the litigant in person hasn't done, but doing so in a way that is alive to the fact that the judge knows this party is unrepresented. You're the lawyers. You're lawyered up, but doing so in a way that balances those two sides. It can be a difficult task, but ultimately one that's in your client's best interest if you do it right. So we'll move on to our final slides. You'll be relieved to hear. Here we're going to talk about the key tips and takeaways, hopefully, from this talk. So firstly, going back to the legal framework, what's important is for you to consider, first of all, do I need to make a relief from sanctions application? Identify the breach that has occurred and identify the type of sanction, if there is one. If there's no sanction, the case law tells us that there's no need for relief. So consider the recent cases, and in particular, I'd go and read or look at Yes Electrical and Warren. That case tells us to think about the particular kind of breach that might have occurred, think about if there's any express sanction, and consider if there's any implied sanction if not. As I say, no sanction, no need for a relief from sanctions application. When doing so, it's helpful, I think, to sometimes start from the back and work forwards. And so it'd be useful when thinking about these things to prepare a draft order for the judge so that you're really thinking about what it is that's gone wrong and how the judge can put it right. And drafting an order that contains recitals about what the breach was and what the sanction that was engaged was, and what relief is ultimately being sought. That can really focus your mind. Make the application for relief promptly. This is always advisable. It's a really important factor, and it's actually something that should be done in all cases involving applications. You should make your application as soon as it becomes necessary or desirable. But it comes down to the third limb of Denton here, all the circumstances of the case. Are you a party, as I said earlier, who just sat on their hands knowing that they were in breach and did nothing about it? Or are you somebody who has recognised the breach, and as I go on to, held up their hands and sought relief as soon as possible? And that's the third point I'd make, is come clean and apologise. Remorse goes a long way, I think, with these types of applications. We've tried to be quite cautious in the advice we're giving about and quite particular, I guess, about the advice we're giving in terms of what's put in a witness statement and so on. And it's for the reason that many of the judges that we encounter day in, day out are very particular kinds of people. And they like it when, unfortunately, when you hold your hands up and say, yes, judge, we made a mistake, we're sorry. And part of that is not only on in terms of the reason for the default, but part of it is conceding where appropriate aspects of Denton. More often than not, this is conceding that there'll be a serious and significant breach.
Yeah, I think that ties in. Oh, sorry, Angus. I was just going to say that.
I'm going to pass on to you.
Yeah, no, I was just going to say that ties in quite nicely with one of the questions we've received, which says, I'm sure I've seen judgments in the past concerning relief from sanctions where judges have bemoaned the tone and or content of the witness statement in support of the application, and have noted in particular the lack of any apology. It seems that a full and frank "I am sorry" is more likely to appeal to a judge's human nature and set the tone from the offset and therefore work in your favour. Is this your experience? And I can certainly say that, yes, it really does help. Again, reiterating what Angus said, judges are often faced on a day-to-day basis with people trying to justify their wrongs. And I think when an application does quite cleanly state, look, I'm sorry, judge, this was a reason, and this is how we've tried to remedy it, and we've still, had to make this application for these reasons, I think it really does come across in your client's favour.
Yeah,
and
I
so
can see. I was just going to touch on that and say that I can see the two sides and the two perspectives that solicitors might have, in that I imagine it's perhaps more of a difficult thing if the default lies with you as a individual or you as a firm. If the fault lies with something that you've done or failed to do, it can be quite a difficult statement to draft and then hand over to the client saying, yes, it was our fault or something like that. But ultimately, as we've stressed, I think it's best to hold your hands up in most circumstances wherever you feel appropriate, because that's what goes down best with judges. What is some of the more difficult situations you can find yourself as an advocate is having to explain a witness statement that is avoidant, that doesn't concede points, that is unreasonably sort of confrontational, and no more so with a relief from sanctions application where ultimately you're seeking the court's indulgence. Yeah.
And just following on from that point is, we all do try and aim for a clean record. So I think the point being made, we've got to aim for a clean record is quite redundant. I think we all try and do the best that we can. So it's particularly difficult to do this when you have a difficult client who isn't corresponding with you. And I think perhaps in those sorts of cases, it's probably quite important then to relay the impact of the lack of any response that they're giving you in terms of instructions and demonstrating to them, actually, if you don't respond, this is what's likely to happen, and these are the cost risks. So that's quite an important tip to bear. Next, support any factual assertions with documentary evidence. Again, I touched upon the importance of trying to exhibit documents where you can, and the correspondence between parties in particular, especially where the application is opposed. Any certificates of service, especially when dealing with litigants in person, for example, who tend to evade any documents ever reaching them and blaming the postman. Thirdly, remedy the breach insofar as you can. I think sometimes, there is this sort of natural human instinct to, we better make the application first, so we can tell the judge how sorry we are, and then let the other side know, and you get sort of caught up in that, when actually, if you just deal with the breach straight away, so that you can mitigate any impact and prejudice on the responding party. So if you have failed to file, for example, a witness statement, do it as soon as you realise, do it as soon as you can, rather than waiting to make the application and then, for example, appending it to the application. And finally, where you can seek the other side's agreement, there is potential cost risk to respondents who unreasonably resist relief from sanctions applications. But also where you are the applicant, then correspondence with the other side can sometimes minimise the cost consequences, because if you can seek an early agreement that the respondent is going to stay neutral, then you know when you're going to make the application, for example, you might tick the box where it says, please can this be dealt with on paper? And therefore, if you are successful in getting a relief, you'll only have minimal costs to bear for the cost of that application, which will make your client happy, which will in turn make you happy, hopefully. So thank you very much for listening today. That sort of concludes our talk. But we are welcoming any questions for those of you who are still around. Thank you for staying around. And we would love to be able to answer any further queries that you may have. Lots of thank yous and no questions. So I'm presuming that there aren't any burning questions. But if you do have any questions, then please feel free to email Angus or I. Oh, one's just come through. Thanks, Daniel. Would you consider that staying neutral but still preparing responsive evidence to draw matters to the court's attention would avoid cost consequences?
I'll answer because it's the part that I dealt with. I think it's a real lawyer's answer for you here. It depends. I think you're at less risk if you're not overtly resisting an application. I think you're sort of straying a funny line by doing it. You're incurring costs for your clients in putting in evidence that on a topic that you claim to be neutral on. There can be advantages to it, depending on exactly what kind of relief is being sought, depending on the reasons for it and what evidence you might have to sort of show why relief shouldn't be granted without overtly doing it. There can be advantages to doing that. I would be surprised if in those circumstances you're going to get allegations from the other side that you should be paying their costs if relief ultimately isn't granted. But I guess it comes down to a judgment call between is it worth the costs of that your client might incur by attending a hearing but remaining neutral and filing evidence, versus whether it is actually an overall an application that's likely to succeed and one that you're not too fussed about being granted. Those are the sort of considerations in a broad way that I think would be relevant.
I would just like to add to that and say that if you are staying neutral, I don't think there's any harm in saying I'm going to stay neutral, but we reserve our position in relation to costs. So when the application is being made, for example, then it might be that you let the application play out, and ultimately when it comes down to costs, if you haven't obviously expended any costs at all, then at that point, sort of raising your hand and say, look, we said that we weren't going to oppose until it came to costs, and it might be that the judge might be willing to award costs that it ordinarily wouldn't have had you put the other side on notice that you are going to raise argument when it comes to costs in respect of the delays that, for example, filing a witness statement and serving a witness statement might have caused, especially, for example, where if you are the responding party and it wasn't until you had notified the other side that they've failed to file a witness statement, for example, on time, and trying to draw out that witness statement, and there are further delays in getting this witness statement until you've heard the application, you might want to reserve your position on costs, but then stay neutral to the substantive application.
I'm just reviewing the chat box there. I think Nothing else has quite come in, but a few thank yous. Thank you all as well. Thanks for attending, for bearing with us on a nice evening. I hope there's some sunshine left for us to enjoy. But please do keep an ear out for future talks from the BPJ series. Otherwise, thank you all for your time.
Thank you, everyone.